We are concerned with a property, my lord, bearing number survey number 464. Measuring 3 acres and 16 gundas.
Kesare Grama, Kasba.
Exactly, my lord. Exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord. It was granted and he was the owner. And he, my lord, had 3 sons. Mallaya, Mailaraya and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I am going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the land is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All right.
Yes. Then, my lord, please look at serial number 6. No, I'm going to skip a few dates, my lord. May not be.
No,
it is given only for the purpose of convenience.
Narrate all the dates, no problem. But rules will go later.
Very well, very well.
Yes.
Now, my lord, please look at serial number 6. Government of Karnataka acquisition of land for development of Devanuru 3rd phase by Muda, 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, the notification is available for your lordship's consideration. Now, my lord, kindly see, interestingly, what happens is serial number 8. Devaraju sought for denotification of land.
Devaraju was not the owner.
No.
Mailaraya was the owner.
Exactly. Mailaraya was the owner because of the 1968 relinquishment deed.
All right, yes.
Devaraju sought for denotification of the land. Endorsement of Muda recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No. It was, in fact, this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there was a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All
exactly.
Right.
And the notification and that relevant property, my lord, is at serial number 40 of the notification. There are number of properties. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There is nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check until I answer your lordship's question. My lord, kindly, I tell you, lordship, my lord.
No problem. Later you can tell us.
My lord, answer to your lordship question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord. I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections. Then, my lord, interestingly, on 25/8/2004, Devaraj, my lord,
Hmm.
sold this property to B.M. Mallikarjun, my lord, who is the brother-in-law of the petitioner. And thereafter, there is a site inspection report. My lord, your lordship gets a site inspection report. Is it in your new list of dates, 5325?
Is there?
My lord, there is
Yes.
one site inspection report
He has
of
taken this
5th of March 2005. Your lordships have seen that, my lord.
2 inspections are done. DC says he himself has inspected
Yes,
it and
correct.
conversion is granted.
Correct. In that, I'm going to point out some very telling facts,
Huh.
which I'll come to. Shall I do it right now, my lord?
Yes, sir.
Please be kind enough to turn to page 125.
Of the objections,
Yes, my lord. My lord, page 125 is a communication from the Tahsildar to the Deputy Commissioner, dated 5/3/2005. Please be kind enough to turn to page 126.
Hmm.
And he says, my lord, he has done an inspection on 4/3, and the last paragraph at page 126. ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಕಂಡಂತೆ
Hmm.
ಹಾಗೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನಿದ್ದು, ಈ ಪೈಕಿ 16 ಗುಂಟೆ ಜಮೀನಿದ್ದು, ಈ ಖರಾಬಿನಲ್ಲಿ 5 ಗುಂಟೆ ಆ ಖರಾಬಿದ್ದಕ್ಕೆ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನಾ ಶುಲ್ಕ ವಿಧಿಸಿ ಉಳಿಕೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರು ಮಾಡಲು ವಿಶಿಷ್ಟ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. ನೌ ಪ್ಲೀಸ್ ಲುಕ್ ಎಟ್ ದ ನೆಕ್ಸ್ಟ್ ಒನ್ at page 127. This, my lord, is
Spot inspection.
spot inspection. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕೋರಿ ಶ್ರೀ B.M. ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮೈಸೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಬಗ್ಗೆ ತಾರೀಕು 17/6/2005 ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುತ್ತೇನೆ. ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಇತರೆ ಸಿಬ್ಬಂದಿ ಹಾಜರಿದ್ದರು. ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ರವರ ಪತ್ರದ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕಾರ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದಿದ್ದು ಖಾತೆಯಾಗಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. This is when acquisition is complete. The question of their being in possession would never arise. This is such a blatant.
No, but it was denotified.
Subsequently,
Huh?
subsequently, the denotification was in 2008.
1998.
1998.
This
Yes.
spot inspection is 2005.
Correct. But it's already acquired. Where is the question of their putting in possession?
No, that is why I asked. Recommendation was made for denotification.
Correct.
Where is the order of denotification?
Nothing, excepting, my lord, what happened on 20th, when, my lord, there was on 18/5/1998.
No, that is an order.
Notification. Yeah, that's a notification.
Then it was denotified.
Yes, it was only on 18/5/1998.
It's all right.
Yes. Yes, my lord.
We don't have auto payment.
Huh?
We don't have the auto payment.
Yeah, if your lordship says, is there a order of no denotification, we don't have it. But
Notification.
notification is 18/5/1998. It is at page 109, which
All
when your lordship asked me, is this the only property which has been denotified? My answer to your lordship's question was, yes, that's the only property which has been denotified. Now, the first question that arises, my lord, is where is the question of this denotification? How can this denotification at all be done? Is it not glaring act of doing something which is not provided by the statute? When the property is vested, where is the question of a denotification? Now, in that context, my lord, if possession has been, if they say possession is with the Devaraju, I ask myself, how did possession go to him? Nothing that is available on record for your lordships to come to a conclusion this way or that. That is the reason why, my lord, it is only in areas where it is a gray area that inquiry is required. My lord, in fact, my lord, the very fact that so much of submissions had to be made to your lordships in order to point out whether the needle of suspicion is to be pointed this way, that way, or none at all, itself indicate that something has required to be looked into. It is only that much that is required to be done today. If it was open, black or white, no inquiry is required. It is only in gray areas that inquiry is required. This is a case falling within gray area. Therefore, my lord, all that is required to be done is just inquire into it. I fail to understand, with due respects, why this case has been elevated to the level of taking your lordship's time over and over again for the simple purpose of simply an inquiry. In a situation of this kind, my lord, let us assume, my lord, the PCA Act was not there and simple complaint had been filed, where there was no this filtration process, my lord. Let us assume it was not there. And I ask myself, if a complaint had been filed with the police authorities.
ಅದಕ್ಕೆ ಫಿಲ್ಟರ್ ಬಂದಿರೋದು.
ಇಲ್ಲ ಬಂದೆ. And it had come to your lordships under 482. I ask myself the question, would your lordship interfere? I would say no. Your lordship would say, look, in the complaint there are some allegations. Let it be inquired into. I ask myself, why is it that same test should not be done for the purpose of 17? 19 is a totally different kettle of fish. It's totally different. 17, is this a case where your lordships will interfere? I ask myself under 482, if a private complaint had been filed in the absence of PCA. Obviously, you will say, look, allegations are there. There are gray areas which requires to be examined. Let it be examined. What's going to happen to you? Nothing. I think, my lord, that is the way. I'm not oversimplifying it.
Just simplifying.
I'm not even simplifying it. I'm only saying, my lord, that's a legal position. And I think, my lord, we have complicated the issue more than what the issue warrants. It requires to be seen in this way. And if that is done, several objectives